If you are waiting for a U.S. green card or you are worried about deportation of a loved one, then this video is made specifically for you. March 2026 has brought 5 major developments in the world of immigration. Some of them offer real hope, and some of them are serious warnings you need to know about. I am Edward, and you are watching Global Entry News. Today, we are going to cover everything that could directly affect your life and your future. Make sure you subscribe to the channel so you never miss an update. And let's get started. In today's video, we will cover the visa bulletin and its latest movement, then a hidden filing option that thousands of applicants are missing out on, then a major court ruling that has blocked third-country deportations, then the restoration of bond hearings for people in detention, and finally, the firing of the DHS Secretary by President Trump and what that means for you. So let's start with the first and perhaps the most exciting update this month. The March 2026 Visa Bulletin has shown noticeable movement in priority dates, especially for employment-based categories. Now, a lot of people ask, what exactly is a priority date? In simple terms, it is the date that determines when you can move forward with the next step in your green card process. When your priority date becomes current, it means your place in line has finally arrived. So if you are in an employment-based category, EB1, EB2, or EB3, this is the month to carefully review your priority date and compare it to the bulletin. The second update is one that many applicants completely overlook, and it could make a massive difference for you. USCIS has allowed both family-based and employment-based applicants to use the dates for filing chart this month, instead of waiting for the final action date to become current. What does that mean in practice? It means you can submit your adjustment of status application earlier than you normally would. And once your application is pending, you become eligible for work authorization and advance parole, meaning you can live in the United States, continue working, and even travel internationally while you wait for your final approval. For anyone with an already approved petition, this is a genuine game changer. Check your priority date against the dates for filing chart right away. Now, the third update is one that touches on human rights and due process. A few months ago, reports began surfacing that detained immigrants were being deported not to their home countries, but to completely unrelated third countries. For example, individuals from India were reportedly being transferred to El Salvador or certain African nations. Think about what that means. Being sent to a country where you have no family, no connections, possibly don't even speak the language, and may face dangerous or unsafe conditions. A federal circuit judge has now issued a ruling against this practice. The court's decision states that immigration authorities cannot deport detained individuals to third countries without clear legal authority and proper due process protections. For now, this practice is blocked. However, legal experts have warned that the government may appeal this ruling, so the situation could still evolve in the coming months. Stay informed and keep your eyes open. The fourth update brings real hope for families who have a loved one sitting in immigration detention. Over the past year, some detained immigrants were being held for extended periods without any opportunity to request release on bond. Imagine the weight of that, waiting on your case, separated from your family, with no path to get out. A federal district court has now ruled that indefinite detention without a bond hearing raises serious legal concerns. This ruling restores the right for many detainees to appear before an immigration judge and make their case for release. The judge will consider factors like whether you have close family members in the United States, whether you have a pending immigration petition, your criminal history, if any, and your record of showing up to court hearings. If the judge is satisfied, you may be allowed to post bond and continue fighting your case from outside detention. For many families, this ruling could mean the difference between months behind bars and going home. And the fifth update is the biggest political development of the month. On March 5th, 2026, President Trump dismissed Homeland Security Secretary Kristi Noem. Her time at DHS had been marked by significant controversy, from aggressive immigration enforcement to protests, legal challenges, and internal investigations. In her place, Trump has nominated Republican Senator Markwayne Mullin of Oklahoma as the new Secretary of Homeland Security, pending Senate confirmation. Noem herself was reassigned to a diplomatic role as Special Envoy for the Shield of the Americas. Now, why does this matter to you? Because DHS oversees USCIS, ICE, and Customs and Border Protection, all three agencies that directly shape how immigration policy is carried out on the ground. When leadership at the top changes, enforcement priorities, processing timelines, and agency culture can all shift. Will enforcement become stricter? Will processing slow down? These are questions we will be watching closely, and we will keep you updated every step of the way. So those were the 5 most important immigration updates of March 2026. Here is what I want you to take away from today. Immigration law moves fast. Court rulings can be appealed. Policies can change overnight. Staying informed is one of the most powerful tools you have. If you have a pending case, or if a family member is currently in detention, please consult with a qualified immigration attorney. This video is meant to inform you, not to serve as legal advice. If you found this video helpful, please give it a like and share it, especially with friends and family who need this information. And subscribe to Global Entry News so you never miss an important update. I am Edward, and I will see you in the next one. Take care.